Because of his stupidity, he bought his son an assault rifle. Not a BB gun, an assault rifle.
I feel like the sheer irresponsibility of Mr. Gray as a parent brought my feeling of a chance to raise my son.
If I say any more, I'm liable to get in trouble.
Emotions were running high in a Georgia courtroom as the father of an alleged school shooter asked to be let out on bail. Multiple family members of victims who were wounded or killed spoke in court, and we will let you know what the judge decided. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Colt and Colin Gray, a 14-year-old Georgia teen and his father, are accused of horrific crimes. Investigators in Winder, Georgia, say that Colt Gray hid an AR-style rifle that his father bought for him in his backpack, snuck it into Appalachia High School on September 4th, 2024, went into a classroom, left a classroom, went out into the hallway, according to security video that investigators testified about at a hearing, and allegedly opened fire. He is accused of firing multiple rounds in the hallway and into at least one classroom. He apparently surrendered when confronted by two school resource officers. 4 people were killed in this attack, 2 students, 2 teachers. Mason Skemmerhorn and Christian Angulo were both just 14 years old. Richard Aspinwall worked as a teacher and a coach. And then teacher Christina Ermy was reportedly celebrating her birthday with treats for her students when she was killed. Many others were also injured in this attack, leading to dozens of charges against Colt, over 50 in total, including malice murder, aggravated assault, aggravated battery, cruelty to children. But authorities also charged his father, Colin, with 29 crimes, including second-degree murder and involuntary manslaughter, for allegedly buying Colt the gun that was used in this attack, or allegedly used in this attack, as a Christmas present, and allegedly allowed him unfettered access to this weapon. A grand jury indictment says that Colin gave his son access to a firearm and ammunition after receiving significant warning that Colt Gray would endanger the bodily safety of another. It is believed that this is the first time a parent in Georgia history has been charged because of a school shooting allegedly committed by their child. We covered the trials of Jennifer and James Crumbly, the parents of a Michigan school shooter. They were both found guilty of manslaughter last year. Very similar situation. James and Jennifer, they bought a gun for their teenage son as a gift, didn't take enough precautions to make sure it was safely stored. He opened fire at the Oxford High School, killing multiple people. Jennifer currently appealing her conviction. But investigators have implied that Colin knew Colt was struggling with mental health issues. And in fact, a year before the shooting, police came to the Gray home after Colt reportedly made a school shooting threat on Discord, the video game social media platform. Colt denied the threat. There wasn't enough more for law enforcement to investigate at that time. But again, distressing piece of information. Now, both Colin and Colt, they have pleaded not guilty. They were locked up. But then Colin's attorneys filed a motion for bond, and a hearing on bond was held this week where the judge had to determine whether or not releasing Colin would present a danger for the community. Very big decision. So Colin Gray was given a chance to testify here. He swore to the court that if granted bail, he would show up to court whenever required. He would follow all the rules of pretrial release. He said if he were to make bond, he had a sister who was a retired member of law enforcement, that he could stay with her. Now, we learned a lot more about the Gray's family situation after the shooting. Colin was married to Colt's mother, Marcy. The two were reportedly going through a divorce. Colt's siblings have recently been in South Georgia with Marcy, while Colt lived with Colin outside of the Atlanta metro area. And during questioning, Colin told the court that Colt had been enrolled in several different schools over the past few years as they moved around. And the prosecutor wanted to know how that was working out for Colt and his schooling, but Colin really didn't seem to have a great answer. He says at one point after a move, he allowed Colt to do online school.
It wasn't too long because I didn't want them to fall behind and whatnot, but I also wanted to give them a little bit of time to process what had happened and just, let them kind of get settled to their new surroundings.
But you did not enroll Colt in school until the next August, correct?
Yes, sir, that's correct.
So from October to August, he was not in school.
Yeah, he was homeschooled.
He was homeschooling?
Online, yes.
Online, were you following that?
Yes, sir, I was.
Signing off on things?
What's that?
Were you like signing off on things?
In the beginning, I was, and he was, he was into it and doing well. And then the more things kind of unfolded with my ex-wife, things kind of escalated on her side of things, and he wasn't as attentive to it as he should have been. So,
How long was he doing the online program? Was he doing it from that October all the way to the end of the school year?
he was off and on. In the beginning, he was on it, doing what he should have been doing, and like I said, as things happened, he kind of slacked off, and the nature of what was being done and said and escalation-wise, I realized it was very hard for him to concentrate as it was for all of us.
By the way, I know we talk about some pretty scary stories here on Sidebar, but you want to hear something else pretty scary? I personally didn't even know about this, but did you know that your personal data is being harvested and sold online by data brokers? Yeah, anyone can buy your personal information. And when that happens, you're at risk for a whole host of things. Identity theft, becoming a target of phishing scams, potentially stalking. But that is why I am so happy to tell you about our sponsor, Delete Me. So Delete Me helps keep your personal information private. I mean, Delete Me found dozens of data brokers with my personal information. It was apparently on all of these different listings. They had to be removed. And here's the thing, Delete Me will keep monitoring the sites for you so your information doesn't find its way back on there after the first removal. And honestly, using Delete Me has given me some peace of mind about my family too, because if someone buys your data via a data broker, they can see information about your relatives too. So right now you can get 20% off Delete Me and protect your personal data when you go to joindeleteme.com/sidebar and use promo code sidebar at checkout. Now, as part of this bail hearing, victims and their family members were allowed to make statements to the court addressing the judge as to why they thought Colin should or should not stay behind bars pending trial. The first to take the stand was Terry McElhannon, who spoke about one of the injured students who's now 15 years old.
Actually, Taylor's dad, your dad's son in the picture, dad and grandpa all in one.
Mr. McElhannon, we're here to discuss the issue of whether or not Mr. Colin Gray should be needed for Angela Bond. If you have something to say on that matter,
I do.
please address the court.
This nightmare began on September 4th, 2024. And now, 5 months later, it's still going on. For some, it will never end. Those who lost their family, their friends, or their loved ones will never forget it. It will always, always be in their minds and hearts. I went to school on that day, September 4th, and I could not find Taylor. I asked several cops where she was. No response did I get. They set up a command center in the middle of the flagpole area, and to no avail, nobody knew where Taylor was. I was told by a student on the football field Taylor was shot. Hours went by. Panic set in on my behalf. No one knew where she was. When she was put on the helicopter at the flagpole, she did not even know her name. And she was transferred to Grady as a Jane Doe. Still, nobody knew who she was. Mr. Gray's caused this. Look at Taylor now. She has a hole in her leg, a metal rod there, and he seeks freedom today. My child, my girl, lost her freedom. We are still dealing with doctors, therapy, and a whole lot of other matters that we can't take in. You took her volleyball playing away from her. You took her childhood away from her. She's only 14, now 15. Why should your son and you have freedom when she has none of it? She cannot do what she wants to do. I want to thank y'all for allowing me to speak today. We're here because of Mr. Gray's indifference, or because he just simply didn't care. I'm not here for vengeance, but to seek justice for my daughter, Taylor Jones. Because of his stupidity, he bought his son an assault rifle, not a BB gun, an assault rifle, knowing the mental challenges that they have. His son made a threat at the prior school, and when he came to Appalachia 2 days later, he carried out his threats. He had a plan of action where he made a hide and concealed his rifle, the rifle that he bought, stupid, and Colt carried out his plan of terror on the school, the victims, the faculty, and the staff. He hurt many students, and he killed 4, 2 adults and 2 children. One was my daughter's greatest friend. My daughter has injuries, and she was life-lifted by a helicopter to grave. She would have died too that day, except for the care that she had received, the blood transfusions, which she actually bled out on the helicopter. She received the best care at the trauma center at Gray, and after many surgeries, not just one, many, she had a steel rod placed in her leg, and we're still hoping that she will recover. As of right now, she still cannot walk. We spent 94 consecutive days in 4 different hospitals. We started at Grady Trauma. We went there to Children's Health Care of Atlanta, CHOA for short. We left there, went north to Arthur Blank, and then we went back to CHOA. And after many visits, I can't count them all, we spent at the ER at Northeast Georgia at night when the pain was so bad that she could not stand it. There have been countless nights of sleep, no sleep, dealing with this tragedy that she has suffered. Mr. Gray and his son carried out an act of terrorism by buying a gun for him, and he should stay in jail as far as I'm concerned, and as far as state is concerned. He should stay there.
39-year-old Richard Aspinwall, also called Ricky by his family, was a married father of 2. Coach A, as he's been referred to, was a math teacher, assistant football coach. Both his father and father-in-law spoke at the hearing about how his death has affected the family.
I can tell you that it's been devastating for my family. I have 2 little girls that's going to be growing up without a daddy, 2 granddaughters. My daughter is devastated. She's lost a job. She's trying to recoup, find a new job. But it's really affected her emotionally as she served 2 tours in the Army. And it struck her real bad. By trade, Mr. Gray, I'm a heavy civil general superintendent. I've had hundreds of men work under my direction. I've seen men like you many a time.
Mr. Aspinwall,
I'm not going to say anything else.
I'm just going to have to ask you to address your testimony to the judge. That's it, who we're talking to today.
I will say that due to some actions instigated or by accident or whatever, that it has affected everybody, the entire state. I've been working with the state to try to make changes, and hopefully it'll come about. But what happened is inexcusable. Inexcusable. I don't know what else to tell you. And if I say any more, I'm liable to get in trouble.
Thank you, Mr. Aspinwall.
No question.
No question.
It's been a tremendous impact in a negative way. We've all been devastated by this. I lost not only a son-in-law, but a close friend. I miss Ricky every day. Every single day. We are blessed with his children, and my wife and I get to spend more time than we should with them. Absolutely more time than we should ever have to have spent with them. I love them, but it's just a daily reminder that Ricky is gone. Ricky is no longer with us. He was a positive impact on those children, absolutely a dedicated father, involved in every aspect of their lives. And it is just so hard to look at them and be joyful for them. And they are beautiful. My condolences actually go out to all of the victims of this tragedy. P.A. Smith said to me in the very beginning, you do not have to be struck by the bullet to be a victim of this. And I couldn't agree more. There have been so many victims and so many people have come forward, and I really had a statement prepared, but I'm not going to read it. I would like to thank the first responders and the sheriff's department that reacted so quickly. I know they saved lives, and they have been so involved with us since. The sheriff himself and Lieutenant Wilkerson and all of them have just been so helpful in getting us through this. As far as the bail goes, I know there's criteria that have to be met, and I'm not going to stand here and judge anyone. It's not my position here. But I do know from, the facts that have come out during the original hearing that Mr. Gray's actions are pretty much responsible for what has taken place. I mean, him buying, I did write down one part that I don't even have to read it, that the statement about a shooter's outfit. When you buy a complete shooter's outfit for a 14-year-old boy, what is supposed to be the outcome of that? The consequences were grave. The decisions he made were unimaginable. I don't know how anybody could do what he did and buy those things for a 14-year-old boy and then not have any supervision, no involvement, no positive parental involvement. And I have 5 wonderful children and have been so involved in their lives and would not trade. I don't know how you can just, I don't know how you can just live with yourself sometimes. I don't know. Because this is horrific. You have devastated the lives of, like Richard said, the whole state, the whole country. This is a devastating act, and I just don't understand. It just makes me so angry that I heard my wife is devastated. She is a ray of sunshine. You've taken her best friend. We did more family activities together than you can imagine. Every chance we did. And Ricky was just a huge part of that. I mean, he was just the most giving person I've ever known. And just a positive influence. I don't think anybody would disagree. He was an excellent mentor. He loved his students. He loved all of his team. He loved everything. He loved life. And you have taken the life of just a fantastic person, and it's just, I haven't slept well since. I really haven't. This has just been extremely devastating. So, like I said, it's not my place to judge, but I would, at this point, seeing the actions and what has come of them, and one of the criteria is threat to society, then I can clearly see where bail should not be allowed for that reason alone.
And then Aspinwall's wife, Shayna. Now, she wasn't in court, but a pre-recorded audio clip was played for the judge.
My name is Shayna Aspinwall. I am the wife of Ricky Aspinwall. Thank you for allowing me the opportunity to express my feelings about Colin Gray and his potential bond release. For the benefit of the court and for the protection of the process, I want to keep my statement short at this time. However, here is what I know and what I feel. Colin Gray knowingly allowed his minor son to have access to an assault weapon. There is absolutely no justifiable reason for any parent to let their minor child, particularly one who has shown some signs of concerning behavior, to have access to an assault weapon. The outcome of Colin Gray's decision was predictable. Along with the families of the other victims, my 5-year-old, my 2-year-old, and I are now forced to live with the consequences of Colin Gray's choice. Colin Gray has clearly demonstrated for all the world to see the type of judgment he possesses. Someone with this type of judgment should not be allowed into the outside world. My children and I, along with the other victims of the Gray family's actions, deserve better. We humbly ask that you deny any release. Thank you.
And I have to say, one of the most heartbreaking moments came when Brianna Skemmerhorn, mom of 14-year-old Mason, approached the stand. She was tightly clutching a Mickey Mouse doll. Mason, who had been living with autism, was reportedly shot in the back by Colt Gray in the hallway, based on testimony from investigators. Let's hear what she had to say.
What we're here to talk about today is bond for Mr. Gray. If you could address the judge and let them know your feelings about bond, not going to get into the facts of the case that you may or may not personally.
So we'll say that I struggle personally with the thought of letting Mr. Gray out on bond. It turns into honestly a matter of letting the judicial system do its job, where he can remain in protective custody, where he's released to the public, where we have more of a chance of street justice taking place. Since my son was murdered on September 4th, 2024, I'm still torn on which should be allowed to happen. I feel that the sheer irresponsibility of Mr. Gray as a parent robbed my family of a chance to raise my son. Mason had a bright and caring future ahead of him. He was an amazing son, brother, and friend, and he loved unconditionally. He possessed an innocence that you could not imagine. For the turmoil that Mr. Gray held incurred on September 4th. At the end of the day, I hope that no bond is granted. And honestly, I'm very under the prison, and him not to allow him to have any impact or influence on any of their children.
And then there was David Phoenix, a teacher who was shot twice, once in the hip, once in the foot, wrote a letter to the court, which an attorney read aloud.
September 4th was filled with hurt, hatred, and darkness caused by a 14-year-old student whose actions were driven by the decisions, choices, and actions of his father, Colin Gray. As a result of these choices and actions, the amount of pain that was inflicted on a school and the surrounding communities was unmeasurable. Lives were lost, people were hurt both physically and mentally, spouses were widowed, parents lost their children, and children lost their parents. There's a degree of everlasting pain and hurt that will never go away and always be felt by students, parents, and members of the community. Our school and community are slowly healing from an immeasurable amount of pain. We have come a long way from 5+ months ago. Releasing Mr. Gray on bond would essentially rip off the bandage of that healing and create the very anxiety, hurt, and pain that we are trying to heal from. Mr. Gray does not deserve bond based on the inexplainable decisions and choices that prompted the deadly actions of his son on September 4th. Conversely, our school and surrounding community deserve peace of mind and comfort knowing Colin Gray is behind bars. It is for these reasons that I'm asking you to deny the bond of Colin Gray.
Once victim impact statements were finished, Gray's attorney gave a short statement about the thresholds that have to be met to keep Gray behind bars, and the prosecutor responded.
This is an unusual case. There have not been any cases of this type tried, only one that I know of in the United States where a parent has been charged with the crimes of their child. I would like to point out, of course, as the judge knows, Mr. Gray is innocent until he goes to trial. He's found guilty by a jury of his peers with competent evidence. That's not taken place yet. The purpose of a pretrial bond is not to punish him before his conviction. The state has the burden of proving each of these 4 areas would be in violation. They have not done that. There's been no evidence that's been presented as to the first area, which is the fleeing the jurisdiction. He has been in Georgia all of his life. He's lived in and around this area. The state pointed out that he had moved a number of times. However, all of the moves are within a fairly short area. Second, poses no significant threat or danger to any person, the community, or any property in the community. The state has not shown that he would pose any significant danger. He had a misdemeanor marijuana charge 26 years ago. That's the only thing that the state has been able to show the court from that standpoint. Number 3, poses no significant risk of committing any felonies while out on bond. The state has not shown that he would be subject to committing any felonies. He's, I think, 54 years old. This is the first time that he's been in any trouble other than the 1999 marijuana. Poses no significant risk of intimidating witnesses or otherwise obstructing the administration of justice. The state has not brought any witnesses before this court to show that he would be any significant risk of intimidating any witnesses. He's been in custody for all of this time, has not caused any problems while there. In custody, has not attempted to contact any witnesses or intimidate any witnesses while he's been there, nor has any of his family. For those reasons, Judge, he certainly is eligible for bond.
A court shall be authorized to release a person on bail. Not that you have to, but you're authorized to release a person on bail if the court finds all of these factors. First one being that the defendant poses no significant risk of fleeing. Your Honor, I think the evidence today has shown that he has no ties to this community. The closest he could come to were some sisters and daughters that live in the metro area, is the best we've heard. He has a history, before the crime, he had an incredible history of moving. He had 7 different residences in 5 years. The next factor, no significant threat to the community. Your Honor, this was an attack on the community. This wasn't a domestic violence where you're attacking a specific person or a robbery where you're going after a specific thing. This was an attack on the community, which makes him a serious risk. There were 25 total charged victims in this case. The next factor, no significant risk to intimidating witnesses. Your Honor, the state is going to need to prove what happened in his household leading up to this shooting. And the witnesses are going to be his wife, his 3 children. Those are our main witnesses in this case. And they're his. And so there's a significant risk of him intimidating or influencing these witnesses. Your Honor, we would ask that you not grant a bail in this case for those reasons.
So the prosecutor said here that if the judge were to grant bond, they would request it be set at more than $1 million. Now, we had Judge Nicholas Prim took over the case after the original judge recused himself. He was retiring soon, didn't want a new judge to have to step in the middle of proceedings. But Judge Prim told the people gathered in the courtroom gallery that there was a lot for him to consider here.
What you, the families, are going through, what the community is going through is it's undeniable pain, and I understand that. The emotions that the community feels are overwhelming, I'm sure. I don't know that you can, but understand that the law does not permit me to be emotional, and I'm constrained by the law. Now, a statement was made, again, understandably, that I'm here to seek justice. Understand that at a bond hearing is not where justice is dispensed. Ultimate justice, in whatever form that takes, comes later through a jury trial. The law at a bond hearing is that the accused is presumed innocent. Now, that's despite whatever's been said about the case through the media or through a first appearance hearing or through any other avenue. as we sit here, the law presumes that Mr. Gray is innocent. No facts have been established in this case yet. Again, despite anything that's been said before. Those facts will come through other hearings, they'll come through a jury trial. Another factor is the danger to the community. Now, if we assume guilt, that danger is obvious. But I'm not allowed to do that. He's presumed innocent as we sit here. There is no independent evidence that he's a danger to the community. There's no recordings of him in jail saying he's going to do this when he gets out. There's no prior crimes where he has done something else that puts those in the community in harm's way. Now, the legislature nor the Supreme Court have said that one of the factors for determining bond is the impact on the victims. It's not one of the factors that I'm supposed to consider in granting bond. Now, having said that, the foremost consideration in determining bond is whether or not the accused will appear to stand for trial. And I do have grave concerns here. This is not the typical case. In an ordinary case, a defendant's given a bond, he makes the bond, he returns to the community, essentially unnoticed by anyone. That's not what would happen here. This case is an open sore. It's a wound that continues to hurt the community. While in court, Mr. Gray is presumed innocent, in the court of public opinion, he bears a scarlet letter. I don't believe that there's any way that Mr. Gray could return to this community as an accused often does when granted a bond. Now, his ties to this community are minimal. The state has pointed out that he has moved and lived in 6 or 7 different places over a relatively short period of time. I am allowed to consider the charges and the punishment that he faces if convicted. And were he to be convicted of these 29 charges, he faces the prospect of the rest of his life being in prison. And that is something I'm allowed to consider. So, weighing all of these considerations, I believe that it is one, required to give a bond, but 2, given the extraordinary nature of the case and the other factors, that it needs to be a high bond. I'm going to grant a $500,000 bond, which is necessary to ensure that Mr. Gray appears at trial. I'm going to require 10% of that to be a cash bond. As a condition of bond, he's to have no contact with any of the witnesses whatsoever.
So Colin Gray was granted a $500,000 bond. He would have to pay 10% of it to be released. He was warned to not have any kind of contact with witnesses or people connected to the trial. And Gray's attorneys have filed a motion to dismiss the indictment against him, claiming, quote, it fails to adequately charge the defendant with any offense against the laws of the state of Georgia. So we'll see which way that shakes up, because no decision has come from the judge on that motion yet. But just another development in a very, very sad case. That's all we have for you right now here on Sidebar. Everybody, thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. I'm Jesse Weber. I'll speak to you next time.